Hey guys, Eric Kaiser with Remax, your host of Probate Café. And today on this episode, we have Brain Mandel with us, and he is an estate planning and asset protection attorney. So he's going to share a little bit about his business, and maybe you'll learn something in the process. So Brian, welcome.
Thank you, Eric. Good to be here in the Probate Café. Right. Coffee's wonderful, by the way. Thank you.
Fantastic. Yeah, I'm glad you like it. Well, share with us a little bit about kind of who you are and how did you get started in this business of estate planning and asset protection?
Absolutely. Well, I am an attorney. I'm a certified specialist in estate planning, trust, and probate law. I'll go into that a little bit, what that means. But I graduated law school, and my last year as a law student, I worked for the district attorney's office. I wanted to be a district attorney, prosecuting criminals and so forth. But if you remember, back in 1996, Orange County went through a bankruptcy because of the controller. You remember this? He kind of squandered all the money for the county, and Orange County actually had to declare bankruptcy.
I do remember that.
You remember that?
Yeah.
So there were no county jobs available. I couldn't get a job with the district attorney's office. So I just had to find another job. And I went one day to the career development office at my school. And back then, they didn't have any internet or anything like that. They had a book of job listings. So I was looking through this book, and I saw that there was an opening for an attorney with no experience as an attorney. I ripped the page out of the book.
That way nobody else will see it.
and I ran down to the office. Yeah. It was in Newport Beach, and it was a little tiny boutique law firm. And I just walked in there, and I said, I'm here to interview for the job. And the lawyer came out, and he was very nice. He met with me. He didn't really meet with me. He just met me. And he said, thanks for coming by. Come back in an hour or two and we'll do an interview, which was really nice. And so I did, and it was a great interview. We really got along well together. And by the time I got home, he had called and left a message saying that he wanted to extend an offer to me. So that's how I got into the business, because all they did was estate planning, probate, and things like that. So I worked there for 6 years, and it was a very, very busy office. We would run through 20, 30, 40 cases a month over there.
Oh, wow.
Really, really busy. So I learned a lot. Learned a whole lot about trusts and wills and probate cases, things like that. And after a period of time, I became aware of the State Bar's program for certifying lawyers as specialists. And so I approached my boss, and I said, you know what? I think it would be a good idea if we took the exam to become certified specialists, because we could charge more for our services. And he thought that was a good idea too. So we both signed up to take the test. It's a full 1 day long bar exam.
Oh, wow.
On estate planning and probate and taxes and stuff like that. And so we both took the test. A few weeks later, the results came back. I passed the test, but he didn't. So that was kind of an awkward conversation, but it was good for me because I said, well, look, Dan, that was his name, Dan, I'm a certified specialist now. I think I should be partners with you. And he didn't want to do it. He didn't want a partner, which is fair enough. And so I left and started my own practice. And that was 20 years ago. So for 20 years, I've had my own firm. And the practice has evolved over the years. Started off doing a lot of planning with trusts and wills and so forth. Probate cases as they come around from time to time. But now, as the practice matures, we're doing more trust administration. After somebody passes away, we have to do some work on that. Still the occasional probates, but a big focus of my practice now is asset protection.
Oh, interesting. Okay.
Yeah, which is really important.
Yeah, to
for
share a little
people.
bit more about that, because I know
Yeah.
there's, with asset protection, there's, I remember there's a few attorneys that specialized that were known back in the day in Orange County. And I think one of them was a CPA / asset protection attorney, really well known. And I don't know what happened to him if he got out of business. This was probably 15, 20 years ago. But
Yeah.
you learn a lot, you know?
Yeah, it's an interesting field, and it's a very important field because everybody's worried about getting sued.
Oh, yeah.
And really, when you think about it, you could have the greatest estate plan in the world, but if you get wiped out with some kind of a lawsuit, you're not going to have an estate to pass on to your heirs, you know? So asset protection is very important for real estate investors, professionals like doctors, lawyers, CPAs, architects, engineers, entrepreneurs, business owners. You know?
I'm sure that asset protection goes well over and beyond a typical trust, right?
Yes, it's a certain niche. There's not that many lawyers that focus on it. I've been focusing on it for over 10 years. So there's only a handful of lawyers really in Orange County that get involved with serious asset protection. But we're using fairly standard estate planning techniques for that. You know, obviously insurance, irrevocable trusts, limited liability companies, corporations, HR procedures, you know, having an employee handbook or procedure manual within the business, and private retirement plans. So we're using these sophisticated, or actually rather traditional techniques, but we combine them into a sophisticated asset protection plan.
Interesting. Now, does that plan ever incorporate IBCs or anything like that extensive? And for those of you listening, not knowing what an IBC is, and I'm sure Brian's looking at me right now, it's like, how did you know that term, right? You're like, I didn't know Eric knew that term. But the IBC is basically an international business company, right?
Well,
or an
yes,
offshore corporation.
There's a lot of, yes. So offshore planning, it's an area of asset protection planning that's a little controversial, okay? I personally don't like that. I think that, frankly, most of the offshore asset protection planning is very risky, okay? Because you're sending money and assets to some other jurisdiction where you really don't have any rights, okay? So I've had clients that have done that, and they lose their investment for whatever reason, you know, and it's really hard to get it back. So also, it's very expensive, Eric, you know, to put together some sort of an offshore trust, or IBC as you call it. You know, client's going to have to spend $50,000, $75,000 just to set that up, and then be prepared to pay annual maintenance fees of $15,000, $20,000, $25,000 a year just to keep it going. So I don't really participate in offshore planning.
Gotcha, yeah.
Because there's plenty of domestic stuff that we can do that works too.
Sure.
So it's much safer, more traditional, and you know, less expensive.
Oh, good. You know, I deal with a lot of investors that purchase, like, for example, these probate and trust properties that I end up selling.
Yep.
They end up making these offers, and some of them, it's kind of interesting. They'll list their name on some of the offers, some of the inexperienced investors, or some of the people that keep doing it continuously. They'll set up an LLC for each kind of purchase, because so there's no tax liability, kind of, or it reduces the tax liability. Because you know, I've run into situations where the purchaser or will have to fill out that statement of information for title,
right?
And even under the LLC, it'll, if they flip a lot of properties, it'll show up as, oh, you have these, and even if there's small amount of unpaid taxes, it could be $230, $500 here, $600 there. I dealt with one transaction where I think there was about 3 or 4 liens, and there were small amounts like that. I'm like, maybe it was a few $1,000, $3,000, $4,000 in total. But I'm like, if you're making this money, why didn't you just pay your taxes and pay?
Well,
It's weird.
Yeah, the whole asset protection thing, it's it's not really to minimize taxes. In fact, a lot of stuff that we do for asset protection will increase the taxes. But that's not the goal. The goal is you want to set aside some things, safeguard them, take the chips off the table, so to speak. And there are always trade-offs. You're either going to give up a certain amount of control over the asset, or maybe you'll increase the tax burden on the asset, but you're going to protect that from lawsuits and judgments.
Here's a question. So I see this a lot as well. And I don't know how much you can go into this or how much you want to kind of go into it. But if someone, for example, I have my property in my trust, but my trust has my name on it. So obviously there's a connection there between myself and my trust.
Right.
Instead of having just a numbered trust, right? So I always thought about that, should a trust that someone puts their home in, should it just be just a blank numbered trust, or is there any reason why they would call it a family trust?
Okay. That's a good question. I get that question a lot. And of course, we're talking about a revocable trust at this point, okay? A revocable trust means you're holding title in a trust. It's your property. You control it. You can do whatever you want with it. It's yours. That means that the revocable trust doesn't provide any protection against a lawsuit, okay? So that's one thing. Now, the whole idea of not titling it under your name, really the only protection that would provide would be a very thin layer of privacy. Okay? I say a very thin layer of privacy because if you purchase the property in your name, right, Eric Kaiser is going to be on the deed to the property. And then when you transfer it into your revocable trust, there's going to be a chain of title that shows that now the property is owned by the number one, Grand View Trust or whatever you call it instead of your name. But it's very simple to check that out. And frankly, privacy doesn't exist anymore. This is 2023. For $200, I can pay to have a lot of information about anybody.
Gotcha, okay.
So I think it maybe gives you a false sense of security if you do it like that. I have clients that insist on it, and we do it, but frankly, it doesn't provide any protection, and it adds a lot of confusion as well, because if you have a trust set up in some name that's not your own name, when you go to your bank or your stockbroker or anybody else like that, they're going to ask for a copy of your trust, and you're going to have to title that account in that pseudonym name, and it's just going to confuse everything.
Interesting. Okay.
Yeah. So it's a good thought, but you don't really need to do that.
Okay. All right. Well, that's good to know, and that's what it's all about: learning and sharing. Kind of some of the ideas. So what can
it's
someone
better?
do?
It's better if you can do this to buy the property within a limited liability company originally. Okay. So you set up an LLC under some name, for the LLC. Purchase the property, have it titled originally in the LLC, so the seller transfers it right into the LLC, and your name never appears on the deed. Okay, that's the better way to do it.
Oh, okay. Wow, that's good information.
Yeah,
that's really good information.
Yeah. Now that's not so easy though, because the financing becomes a little bit more difficult, and the insurance, when it's in an LLC, but that's the preferred way to do that.
Okay. Yeah. And if someone's looking to set up or, evaluate kind of asset protection based on their personal assets, what should they consider, or what can they do to protect their assets?
Well, there's a lot. First of all, we look at insurance. All right, liability insurance, umbrella policies, transfer the risk onto the insurance company if we can. Right. Then we look at the laws, okay? So there's statutes out there that we want to take advantage of if we can. Typical statute that most people are familiar with would be your homestead exemption, okay? If you're living in a home, California will shelter up to $600,000 now of equity in your home from any kind of judgments, okay? Another statutory exemption that we have in California and it's one of the few ones that we have, other than the homestead exclusion, is for private retirement plans. Okay? Most people are familiar with a IRA or a 401k plan for retirement, right? Mm-hmm. 401k is under the federal ERISA law, which protects those assets. So if you have a 401k plan, any money that's in there is exempt from creditors. They can't touch it, okay? Which is nice. The other nice thing about a 401k plan is that when you put the money into it, you get a tax deduction, right? However, they're not that useful for asset protection because there's limits on how much you can put into a 401k every year. You can't just throw everything in there. You can put, $20,000 or so. That's the most every year. And if you're a business owner, you have to pretty much cover all the other employees in the business in the 401k plan also. And there's a lot of administrative rules and third-party administrators that are required for a 401k plan. So that's not a real great asset protection strategy. However, the state of California has a law, Civil Code Section 704.115, where they allow, I even knew that, the code
that's
section.
right. That's
you impressed?
Yeah.
They allow a business owner to set up a private retirement plan. So it's not covered under ERISA. You don't get a tax deduction, but whatever you put in there is exempt from your creditors. So because it's not an ERISA plan, there's no requirements to cover other employees. There's no limit on how much you can put in, theoretically, all right? And it's not tax deductible either. So it's a tax neutral type of thing. But I've got many, many clients that want to take some chips off the table, put it into a safe vehicle for their retirement plan. And once the money is in the retirement plan, or once the asset is in there, it's protected. And it's even protected after the client retires and it comes out of the retirement plan. So it's a really good deal.
Wow. Okay. There's a lot involved, more than I thought.
Oh, yeah.
Well, I guess that's why they have the professionals, right?
Yeah, it's complicated.
Hey guys, I hope you're enjoying the content you're watching or listening to right now. And if you'd like, please subscribe to the Probate Café channel on Spotify or check us out on YouTube. We've got a lot of valuable information that we share, always keeping you updated in the field of estate planning. Thanks for watching. So here's another question.
Mm-hmm.
What is a bloodline trust?
It's a very painful trust.
It sounds like it.
No, bloodline trust, that's simply a trust that's set up that is providing asset protection to the beneficiaries, okay? So if you consider a typical trust structure where, or will, whatever, where the person passes away and the children inherit from that person, well, if it's an outright distribution to that beneficiary now can take that and do whatever they want with it. They can commingle it with a spouse. They can use it for whatever they want to do, which is okay. But the problem is now, if that person subsequently gets involved in some sort of a problem, let's say they get in a car accident and they get sued, or a business deal that goes wrong, right? Or 50% of all marriages end in divorce, so that inheritance winds up being at risk, okay? So a bloodline trust is different because with the bloodline trust, your family trust continues even after you pass away, and the beneficiary that you've designated can reach into the bloodline trust and use the assets in there, but they're never retitled out of the trust into his or her name. See? So the whole concept is, if that person does get sued for whatever reason, divorce, car wreck, business deal, tax problem, the creditor can't get what's not in that person's name. See? It's still in the trust.
Okay.
And so it's kind of like, I explained, it's kind of like setting up a prenuptial agreement in a way for the children without even them being married yet. Okay? So it's very strong asset protection for the kids.
And they probably won't even know about it, right?
Well, not until,
They pass.
not until the parents pass away.
And then it's already set. So if they
It's
have
all
issues,
set up, and now they have a nice bloodline trust that they can use. They can enjoy all the assets, but it's safe. If they get into any kind of a situation, those assets are not at risk.
So if, say, for example, your parents pass away and you're married, and then shortly after that you end up getting a divorce, those assets do not become part of the divorce, basically, right?
Correct.
Okay, so that's
Exactly.
that's a really good idea then.
It is a really good idea.
Well, speaking of good
You
ideas,
should do it.
I'm not married, but yeah, yeah. I mean, that's the thing people don't think about is
It's a great idea. Probably
you know?
half of the trusts that I do it like that, and it's a very natural thing because when I'm talking to my clients, many times they'll say something like, our son is married and we don't really like his wife too much. She's, it's kind of a rocky marriage and we don't like her too much. So is there any way that we can protect that so that there's no way that he can just, inherit from us and then, put his wife on title to the new house or whatever? And yeah, I have a solution for that. It's called a bloodline trust.
nice. And then I'm learning a lot. As far as real estate goes, and I know we were talking about LLCs, and it was interesting how I spoke to someone they were selling boats and yachts, and so typically what these people will do is buy these big $1 million yachts, but they'll buy them under an LLC, so they don't have to pay. They'll just transfer the LLC, right? They don't have to pay sales tax or something like that. Is that? I don't know if that's the same thing. But,
I don't know about that, but it's a good idea to have that boat in the LLC.
Okay.
Because of the liability protection.
Gotcha.
That's really the benefit of an LLC. It's a limited liability company. So if you're on the SS Minnow and you crash into another boat, they're going to sue the LLC that owns your yacht and not you personally.
Okay, so that should be every boat owner.
Every boat owner should do that. Yeah.
Wow. Okay, I bet you they probably didn't, or don't.
Well, I don't know.
Yeah. Anyway, but
every boat, every plane, every airplane, same thing.
it's like when you buy those, you really got to think beyond just buying it.
Yeah.
Okay, well, how about capital gains? How can someone avoid capital gains when selling property?
Well, okay. Typically, this is a situation where you've got somebody that's been a landlord for a long time, and it's been great. Being a landlord is a good way to build wealth and cash flow and all that. But it's work, and now they're sick of that. They don't want to be a landlord anymore, right? Well, I do have a solution for that where they can sell the property, not pay any capital gains, okay? And they get to write off on their taxes about half the value of the property, okay? So they get a tax deduction on that. That sounds pretty good.
Yeah.
Yeah. Okay, so this is called a capital gains bypass trust. Okay?
Capital gains bypass trust.
That's what I call it.
Okay.
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 It has another name too,
Okay.
but I call it a capital gains bypass trust. And essentially what you do is you create this trust. Now, this is an irrevocable trust, so it's not like your typical revocable trust. It's an irrevocable trust. You create it, you are in charge of it, you're the trustee of it, okay? And you're going to designate a charity as the ultimate beneficiary of that trust, okay? So you pick a church, a school, some kind of charitable organization, whatever you like, okay? And that's going to be the remainder beneficiary of that trust. The other name for the capital gains bypass trust is charitable remainder trust.
Okay.
CRT, okay? So once you do that, you transfer your property into the trust, okay? When you do that, you get a really big tax deduction that you can apply that year or for the next 5 years. Write that off of your taxes. Then once it's in the trust, you can sell the property, not pay any capital gains tax, okay? So the full amount, the full proceeds is in that trust. You can then invest that money into the stock market, bonds, annuities, some kind of passive type of thing, because they don't want to be landlords anymore. They're not going to buy real estate again. That's why they're not doing a 1031 exchange, right?
Okay.
And so this money is invested in this charitable remainder trust or capital gains bypass trust, and then they take money out of it. Every year, you're going to take between 5% and 50%, depends on how old the client is, but they're going to take that money out every year for the rest of their life. Okay? And then, ultimately, at the end of the trust, which ends when the client passes away, whatever's left in there is going to go to the designated charity.
Oh, nice. Okay.
So it really works well when the client has a charitable intent to begin with, but even if it doesn't, it's a great way to avoid those capital gains taxes, get a substantial tax deduction, and increase your annual income too.
Yeah, I guess every situation is different. You don't know when you're going to use it, and
yeah,
so
that's
you got to
right.
put all these pieces together like a puzzle, right? And
exactly. It's
figure out
a
what's best.
sophisticated calculation. You know, I have the software that we need to plug in the client's age, the cost basis of the property, all that kind of stuff goes in. The computer does a model, and we run some illustrations, and that's how it works.
Oh, okay.
Yeah,
Yeah, it makes it easier.
CRT.
CRT.
Or
Okay,
capital gains bypass trust.
Well, share with us what are some of the misconceptions about trusts?
Well, there's a couple of them. One is that, and we talked about this briefly, one is that if you put your assets into a revocable trust, they're protected from lawsuits. And that's just not the case, okay? In fact, even if you put your assets into an irrevocable trust in California, if you're the creator of the trust and the beneficiary of the trust, those assets are not protected either.
Oh, wow.
In California. So, yeah, that's one of the misconceptions. The other one, which is probably a more subtle misconception, Eric, but one that I think is really widespread, is that a living trust will avoid all the administrative expense of settling somebody's estate. Okay, and that's because I think, you know, we've been selling trusts so hard over the last 50 years as a way to avoid probate, and everybody knows probate's expensive and it's time consuming and it's all in the public domain. So everybody wants to avoid probate and the expenses associated with probate. So people think that a trust avoids all that, and it doesn't. Okay, a trust will avoid probate. That's true, but all the administrative functions that happens during a probate, you still have to do with a trust. Okay, we still have to clear the title to the real estate, still have to get control of all the bank accounts and investments, still have to pay off creditors. Okay, so all those things still need to be done, and there's expense involved in that. Okay, however, it's a lot less than a probate is, much less, and it's a lot quicker and easier and more streamlined, because all of that administrative work, instead of petitioning the court for that and taking a year and a half to do, all that's done in the lawyer's office. So in a matter of months, usually, weeks or months, we can go through the whole administration. Okay. But it doesn't eliminate it altogether. And most people are surprised to learn that, oh, it's not automatic? No, it's not automatic. I'm sorry, but that's just the way it is.
I run into some clients that they're administrating the trust after someone passes, and there's a lot of work involved.
Yeah.
And they didn't realize it, and they're like, I never wanted this job in the first place, and it takes up so much time.
Right.
And I said, well, talk to your attorney. Maybe you can get paid. I don't know if that's something you could do.
Well,
but,
they can get paid, and you know, the fact is, if they're complaining about the trust administration, because it's a lot of work, multiply that by 10. And that's what would have happened if there was not a trust. If it was in probate, it's way, way, way worse.
Yeah, especially if they're pro per, right? So it's just a nightmare.
Yeah.
So if anybody listening or watching, if you're doing probate or you're going through probate, you're going to start probate, reach out to Brian. He can help you in California, I assume, because that's something, if you're going through, a lot of people go through that and they're just stressed out. They don't know what to do. And it takes them years just to go through that. And then I'm sure there's other beneficiaries. They want to be paid out, and it's just a nightmare, right?
It is a nightmare. It's horrible. It's really bad news. I actually did one where we did have to do it in another state. And that's okay because the person died, a resident of California, but he owned real estate in Minnesota. So what happens in a case like that is you have to open up a probate here, and you also have to deal with the court in Minnesota. It's called an ancillary probate. So, yeah, it's even doubly complicated.
Oh, wow. Yeah. So anybody, yeah.
And with a trust, it does eliminate the probate, so it's a lot quicker, a lot better.
But still a lot of stuff. If you're
Still-
not familiar
still a lot
with
of-
it, it's
lot of
best to
stuff.
hire an attorney.
Absolutely.
For sure, because
Yeah.
it's going to drive you crazy, right?
Yeah.
And it's just,
Drive the attorneys crazy. They're crazy anyway.
that's right. That's right. they're used to it. And how long? So somebody's going to set up an estate plan, or obviously they haven't set that up. They own property. They're getting up there in age, or someone that's young and your parents are getting up there in age. How long does that take to set up?
Well, usually after the information is gathered from the client, we have to know the names of the kids, and we basically have to design the estate plan, right? So once we meet with the clients and we design it like that, to complete the estate planning is about a week or two. Okay. Now, that's based on the client's schedule. They might not be able to come back within that time frame. They might stretch it out a little bit longer, but if everything goes smoothly, a week, 2 weeks.
Oh, that's pretty quick.
Yeah. Now, once that's completed, we transfer the real estate into the trust, which we do the same day. It's very simple with a deed. But then the second part of this is they need to contact their banks, their stockbroker, their financial planner. They might have to change the beneficiary designations of their life insurance policies or their retirement plans, depending on who the beneficiaries are. So there's a little bit of homework to be done. But that's why the trust works. That's why the trust works, because the whole idea of a trust is we want to avoid probate. Well, probate is, when you boil it down, it's simply the process of changing the title from the dead person to the living person, the heirs, right? That's really what probate's all about. But with a trust, we're changing the title ahead of time while the parents are still alive.
Yeah.
Okay? So they have to do that after the trust is created. And that takes, another week or two usually to do that.
Okay. So I would say also, if someone's listening that your parents are up there in age and you're not sure if their property is in a trust, reach out to me anytime, because we can pull what's called a property profile, and we can just look. It should show if it's in a trust.
Yeah.
And that'll tell you for sure if your parents went ahead and created a trust, if you don't know, or if you want to make sure that it was put into the trust. Because a lot of times on those refinances, sometimes they'll forget to put them back in the trust, and you don't really know it. If your parents refinance over the last few years, and it's just something to check, because if you don't know, then it just complicates things down the road.
Yeah, it's a nice surprise,
Right? Nice
hear,
surprise.
We got to go to probate. What?
Yeah.
Now in a case like that, there's a special petition. I think you and I have been involved in one or two of these, where it's called the Hegstad petition, right? That's where they have a trust. For whatever reason, they pull the property out of the trust, usually to do a refi, and they don't put it back in. In that case, we can petition the court under the Hegstad case and have the order transferring the property back into the trust, which avoids the full probate. It's not ideal because we still have to go to court to do it, but it's much less expensive and less of a problem than a full probate is.
Okay.
Yeah. So if somebody has that situation, that's how we address that.
And obviously working with the trust is a little bit quicker, right? The probate process that's months or years.
Yeah.
Could be because you got to reach out to the creditors. They've got to submit claims, and if there's somebody's trying to contest a claim, and there's all sorts of weird stuff that can happen.
Anytime you get into the court system, it goes sideways.
Oh yeah.
So yeah, if you can get this out of the court and into the trust and have it administered privately. Without the court involved, it's much better.
And having a good trustee, right? Because I've been in some situations where a property was probated, and there was 5 or 6 beneficiaries, but the one administrator for the probate did not act, like just wanted to keep the family home and just dragged this thing out. So now you've got other beneficiaries trying to have them removed, so they got to go to court.
Yeah.
So it's a whole nightmare if you don't have a good trustee.
That is so true, because the trustee is in a real powerful position, okay? And I always say that a great trust can be completely defeated by a lousy trustee. All right, which is the case that you're describing, okay? This person's not acting as the trustee. He's not performing his fiduciary duties.
Oh, yeah, this one is a probate administrator, but kind of the same lines, right?
Same thing, yeah. Even worse because it's in probate court. So, yes, if you have a bad fiduciary, whether it's an executor or a trustee, it's going to be very problematic.
Wow.
Yeah, really tough. You can petition to remove them and have them surcharged and all that. But who wants to go through that?
Yeah, it's a nightmare.
You got to pick a good trustee.
Yeah. So, when we're talking about trust setting up, the basic estate plan, what are some of the costs? I mean, I'm sure, they vary to some degree, but I don't know if you're comfortable sharing that. But obviously the cost, whatever the investment is in that, outweighs the going through probate and that expensive process for sure.
Yeah. Well, typically an estate plan a basic estate plan will consist of a revocable trust, pour-over will, durable power of attorney, and a healthcare directive. Okay, and there's a few other documents as well, but that's what your typical trust-based estate plan will consist of. Now, all of that to put together is about the same price as a will, okay? So if you don't do a trust, you're going to want a will. You still need a durable power of attorney. You still need the healthcare directives and all of that. So they're about the same price to set up initially, all right? And depending on the situation of the client, whether it's a single person or a married couple, other complications could be a blended family. Those are a little bit more complicated. If there's LLCs involved and so forth. The typical fee to do that's going to run between $2,500 to $5,000. Okay? So that gives a broad range of fees there, but that's pretty much what they're looking at.
Well, and you're going more in depth in the conversations because these online portholes or whatever they're doing, that's kind of point and click, do this, this, and this, but they don't account for all these other things that could happen, right? And all the other discussions, right? That's the concept of the service that you provide. It's just more in depth. It's not just a kind of, we set us up with a trust here at $99 or whatever it is, right?
Well, anybody can do that. Anybody can go online and do their own DIY estate plan. But, is it going to work? Did they leave something out? I've seen a lot of problems with cases like that.
Yeah.
So what a client is paying for when they're working with a lawyer, whether it's me or any other lawyer, really, it's the relationship with that attorney, so that when somebody does eventually pass away, you have somebody to guide the surviving spouse or the kids on what to do, all right, and how to maybe correct any mistakes that might have been made, all right? So that's really why people hire lawyers. It's for that relationship and for that advice and counsel.
And you want someone like yourself that specializes, because I've seen some situations where maybe a family goes to a personal injury attorney or something like that, and then they think they can do a trust, and it just.
I think it's a good idea. That's why I became a certified specialist many years ago.
Yeah.
Because there's a lot of lawyers out there. I call them a door lawyer, which means that they'll take any kind of case that walks in the door. One day they're going to take a divorce case. The next day a client will walk in and it's a personal injury case or a criminal defense case, and then somebody comes in with a will or a trust that they want to do. So there's a lot to know. There's a lot to estate planning. It's not simple. And especially when you throw in the asset protection component to it.
Sure.
If you're not really a specialist in this field, you shouldn't be doing it.
Yeah.
I wouldn't take on a divorce case. I wouldn't take on a criminal defense matter.
Right.
So lawyers understand that, but I think most people understand that too. That if you're going to do your estate plan, go to a lawyer that does that. Most of the time, or all the time, like in my case.
Hey, you don't go for heart surgery. You don't go to a brain surgeon for heart surgery, right?
That's what they say.
They're both great, but one has a specialty and one does not.
Yeah, exactly. Right.
Well, and if you're listening to this and you don't have an attorney, reach out to Brian. How can they reach out to you? What's your website, or how can someone get a hold of you?
Well, of course, I do have a website. That's www.brianmandellaw.com. You can just Google me, Brian Mandel. It'll come up. It's very easy. My phone number, 949-660-0007. So that's kind of easy to call me and
reach out to you.
Reach out.
Anywhere in the state, or you basically California? So somebody's in San Francisco listening to this or watching this, they can call you and
yeah, I have a lot of clients all over the state.
Okay.
Mostly in Southern California, but I have many clients, hundreds of clients in Los Angeles. I've got clients in San Francisco, all the way up the state.
Oh, fantastic.
Yeah. And I'm only licensed in California, but there's plenty of people in California
that need you.
I'm pretty busy. Don't worry.
Well, thank you for sharing all your valuable knowledge. We really appreciate you being on the show.
It was great.
And again, guys, tune in for the next episode of Probate Cafe. And we always try to bring you some valuable content that you can learn from. And again, thank you, Brian. We really appreciate your time.
You're welcome, Eric. Thank you very much. Really appreciate it.
Definitely. Thank you.
All right.
Hey guys, thanks again for watching. You can always look forward to some valuable information from professionals in the industry of estate planning and probate and trusts. Thanks for watching. We'll see you next time on the show.